That work? Okay. Thank you all for coming to this Fair Search press conference. I think you can imagine how delighted we are by the Commission's decision today. Fair Search, just to introduce it, is a group of companies that promote online competition, but has been a key voice in the complaints against Google, and notably in the so-called search case. Today, I'm delighted to have two speakers. Siobhan Raff, co-founder and CEO of Foundum. Foundum was one of the first company to file a complaint against Google in 2009. And Thomas Vigne, legal counsel and spokesman for Fair Search, and also global chair of antitrust for Clifford Chance. Each of them will, make a 5-minute statement. Thomas will provide an overview of the case, the principles, and Siobhan, who has direct experience in the online and comparison shopping sector, will provide specifics of her case. Afterwards, we're going to open this press conference to questions from the floor, but also online. People who are listening or hopefully by now watching can send questions to press@fairsearch.org, and we will ask the questions for you. I'd also like to say that Thomas is very willing. I think you all may be aware that Kent Walker has published a blog on Google's position today, and Thomas is very willing to reply point by point on it if that interests you. So first, over to Thomas.
Thank you, Elizabeth. Well, here we are. Finally, a decision condemning Google for manipulating its search results and devastating competition. Finally, Google is being ordered to cease favoring its own services and to provide equal treatment to its competitors. This is the search decision Fair Search has been waiting for. The remedy imposed by the European Commission is the one we asked for long ago. It's a principles-based one that can be easily implemented. It establishes certain key principles, in particular, equal treatment for both Google's own services and those of its competitors. It's thereby flexible, and we believe it will stand the test of time. Google remains entirely free to innovate, and we certainly hope it will, but it will no longer be allowed to abuse its search monopoly to favor its adjacent services. So who wins? Competitors will now have the chance to compete on the merits, but most importantly, consumers will receive unbiased, unmanipulated comparison shopping results. If they search for a product for sale, they'll receive the most relevant results and not automatically those that line Google's pockets. Google search results are not now, previous to this decision, designed to deliver the most relevant results or the best prices to consumers, but instead to make the most money for Google. Therefore, consumers have faced a reduced choice of goods and services and ultimately paid higher prices than they would have done had Google provided objective results and not those that make it rich. So this decision means that consumers will receive comparison shopping results that offer genuinely the best purchasing options. So what happens now? As the commissioner said herself earlier this morning, Google will now have to propose how to implement this equal treatment principle. This is the normal way the Commission proceeds in such decisions. There was a lot of hot air about how much detail the Commission might provide in its remedies. A lot of discussion about that. Rather a waste of breath. It's rather normal, it's completely normal for the Commission simply to establish certain principles, throw the ball into the court of the defendant, and require it to propose the specific means by which it will implement the orders. We hope Google will play no games with this. It's not difficult to implement this remedy in a way that, as I said before, enables Google to continue to innovate. There have been some rumors about the possibility of Google returning to the 10 blue links that were provided some years back. Siobhan can explain why that is absolutely not required by this decision. It is perfectly feasible for Google to provide the same sorts of results it provides today in terms of the format and the pictures and all of that stuff, but to provide those sorts of results giving equal treatment to all of the comparison shopping services so that their results are provided in the same way. What about the other cases, travel, local, and the like? It appears that today's decision sets a powerful precedent that the Commission can use immediately to restore competition on the merits to other specialized online search services such as those, travel, local, and the like. First, this decision establishes dominance on the part of Google in general search. That, of course, is the fundamental building block for any decision under Article 102 of the EC Treaty. We have not yet seen the actual decision. We've heard the Commissioner, we've seen the statements issued by the Commission. It appears, however, that the principles that will be established with respect to how liability is found, in other words, what sort of conduct by Google will infringe the law, those principles seem to be pretty well established in this decision, and so the Commission will have not only a binding finding of dominance on the part of Google with respect to general search, but also rules of the road with respect to its conduct related to adjacent markets, adjacent vertical search markets. So we expect, as the Commissioner already indicated, it will do, and it really has to do, that it will proceed rapidly to further investigate those cases and apply the principles to those cases. Let me move on very briefly to one of the two other remaining investigations that are open, the Android investigation. FairSearch filed a complaint in 2013, pursuant to which the Commission launched its Android investigation as to whether Google is abusing its dominant position with respect to mobile operating systems. And we strongly encourage the Commission to proceed rapidly to finalize its decision in that case. Google is seriously distorting competition in the mobile sphere, and it needs to be addressed, including in particular the question of whether consumers' data is being inappropriately combined, and otherwise Google is engaged in conduct related to data that it should not undertake with respect to Android. And then let me finally address one of the points which appears to be a topic of great interest, and that is the question of whether this decision is somehow motivated by anti-American sentiment. I've been hearing this refrain for decades now. IBM said it in the 1980s and 1990s. Microsoft said it very loudly and repeatedly during the end of the 1990s and into the 2000s, and Google has now been saying it, and others appear to believe it. We would very emphatically, and I personally, having lived through these cases for decades and knowing the Commission officials involved in these cases, would very emphatically reject the suggestion that this decision is in any way motivated by anti-American sentiment. The European Commission pursues US technology companies in dominance cases because they're the ones who dominate that industry. In industries where European companies dominate, look at energy, transportation, and often financial services, the Commission pursues them, not American companies. If you look at the numbers, you'll see this. So the determining factors are, is there dominance, and is there an abuse of that dominance? Nationality is not the factor. I suggest look at the cases. The facts speak for themselves.
Thank you, Thomas. Thank you, Thomas. Over to Siobhan, who will talk about Foundum.
So, as you can imagine, we very much welcome today's decision by Commissioner Vestager. And in particular, although obviously the record-breaking fine is likely to dominate the headlines, we welcome the associated prohibition of Google's immensely harmful search manipulation practices. Although I'm not a lawyer, I do feel that there can't have been many cases where the stakes for consumers, businesses, and innovation were any higher. As we all know, for well over a decade, Google's search engine has played a decisive role in determining what most of us read, use, and purchase online. And left unchecked, there are few limits to this gatekeeper power. Google can deploy these insidious search manipulation practices to commandeer the lion's share of traffic and revenues in virtually any sector of its choosing, quietly crushing competition, innovation, and consumer choice in the process. And today's decision and associated remedy will restore the level playing field on which all innovation depends in order to thrive. There are a couple of key points about today's decision that I just wanted to shine a spotlight on. And the first is that the Google search case is not just about Google's comparison shopping service. It's always been about Google's core search results and the illegal practices that Google uses to manipulate them in order to steer traffic to its own adjacent services and away from competitors. And as Commissioner Vestager made very clear today, although the Commission has chosen to constrain the scope of its formal decision to Google's application of these illegal practices as they affect the comparison shopping market, this decision sets a precedent, and the final remedy is therefore likely to extend far beyond comparison shopping to also include travel search, local search, and other existing and future specialized services. Some of you might have noticed that Google, for example, recently announced it was moving into job search. So this decision is a precedent that will prevent Google from buying or launching some merely adequate job search service and then preferencing it, demoting competitors, and thereby co-opting the vast majority of traffic and revenues to that new market. Thomas mentioned that the remedy that the Commission has made clear it requires is a principle-based remedy, the even-handed remedy, which essentially states that Google's search engine has to hold all services, including its own, to exactly the same standards, using exactly the same crawling, indexing, ranking, and penalty algorithms. So just to go into a tiny bit of detail about that, one of the main advantages of this, because it's principle-based, it's resilient to future innovations and developments. And what it will look like in practice will be entirely up to Google. So Google is left free to pursue any developments and innovations it wishes, and it can display rich display formats in any format it wishes. But the only difference will be that under this non-discrimination remedy, the search results afforded these enhancements will be based on their relevance to the user's query rather than on Google's financial interests. And as things currently stand, Google has a broad range of implementation options available to it, and apparently it has 90 days to pick one and then implement it. And these fall into two broad categories. So one option preserves universal search, where universal search is Google's mechanism currently for inserting its own services at or near the top. And Google could, if it wishes to, retain that and somehow find a way of incorporating competing services alongside Google's own on a level playing field. The other option, so that we'd call that inside the box, the other option outside the box would be to switch off universal search, switch off these anti-competitive penalties, and instead entrust the selection and ranking of all of these services, including Google's own, to Google's core crawling and ranking algorithms minus anti-competitive penalties. And we would say that that second option is by far the most straightforward to implement, could easily replicate all of the rich display formats that Google has introduced over the last few years, but crucially is pro-competitive and much more desirable for users, and could be implemented, quite frankly, in weeks or just a couple of months. Thank you.
Thank you. Thank you, Siobhan. Thank you, Thomas. Okay, now I'm opening the floor and online to questions. I'm looking at, I do not have any questions, David. But we have one in the room. Aoife, please identify yourself and your media, please.
Aoife White from Bloomberg. A question for Siobhan and for Thomas. Given that we've been through a settlement procedure, in some ways we're looking at another kind of a settlement procedure. We're trying to find remedies. Do you expect that you would be part of that discussion in any way? Do you think you would be testing the remedies that Google would be putting forward?
Maybe you'd like to go. No, go for it.
Yes. I mean, that would be entirely normal. I can speak, as you know, from my Microsoft experience and other experiences. Yes, there it is. I'll respond again. Yes. So, I mean, that's the way it normally works, of course, that complainants and interested third parties who have relevant knowledge about how the markets work, the technology works, are involved in discussions with the Commission about how the remedy should be implemented. In particular, even if there might not be formal market testing in the sense there is when there's a settlement proceeding or a settlement process, the Commission, I would expect, would informally market test with us and others Google's proposed implementation. It's a rather natural thing. That does not mean, of course, that they're going to simply take whatever we say and impose it upon Google. But rather long-winded way of saying, yes, they will consult us and they should, as they have in the past. No, the Commission has not. We will seek interaction with the Commission, but we don't know exactly how that will work or the timing of that. But the Commission has not asked us yet for anything.
I think, given that this is such a technically complex area, and in particular, given that search bias can be very hard even for experts to detect, we would hope that the Commission would be open to assistance to evaluate any proposals that Google puts forward. And we look forward to offering all possible assistance on that. And certainly, from our point of view, one of the things that we suspect might be helpful would be, once Google has made a proposal, potentially three-way meetings with Google, the Commission, and select competitors might be a really good way of shortcutting any confusion or obfuscation that might just sort of mount up due to the technical complexity.
But you would like to see some, just to show that the traffic is going to others, some kind of just a meter to show that traffic is going back to some other comparison sites?
Well, I think there are ways of monitoring search results to detect residual bias. But I think it's important to remember that the bias at the moment is absolutely brazen. So you put in any product comparison relevant query or any travel query, any commercial queries, and you will almost always see Google service very close to the top of the search results. And particularly in comparison shopping, as Commissioner Vestager was saying today, on average, the competing price comparison services are demoted to page 4. So that is extraordinarily brazen bias. So in order for Google to look the Commission in the eye, put its hand on its heart and say, right, we have restored a level playing field, they're going to have to have fixed a good 95% of that issue. So then the remaining bias, the devil will be in the detail. But I think everyone will be very, very pleased to get 95% of the relevant traffic that they should be getting back, and then there'll be an ongoing monitoring process to deal with any residual remaining bias.
Maybe a couple of follow-up points on that. As Siobhan could...
He has.
I did. As Siobhan, perhaps I should lead this to you, but as I think most of you know, but I think it's worth emphasizing, the way it works today is that if you, as a user, put a search query in about a product you're interested in buying, for some reason Adidas shoes and Nike cameras are the examples always used. So you put in your Adidas shoes. I'm not in the market for Nikon cameras. Anyway, you put in your Adidas shoes, then the Google algorithm immediately detects that this is a search query that might indicate that the user is interested in purchasing that product. And then it will automatically, it's hardwired into the system, the Google algorithm will automatically place its comparison shopping service at or near the top. Now, the Commission, as I understand it, explicitly requires in the decision Google to abandon that fundamental mechanism and to employ the same selection mechanism for all comparison shopping services. Today, it privileges its own comparison shopping service automatically right up front. That will have to end, and it would be very surprising when that is ended and the same selection mechanism applies to everybody if the results we see are not dramatically different from the ones we see today. Following up a bit and going further into time, again, it would be surprising for the Commission not to consult with us and others about the proposed implementation that Google comes up with, but also going forward, it's going to be open to, I'm sure, information from us and from other participants in the market about how the remedy is working. One thing I've noticed is that as far as I can tell, there's no trustee in this decision. So the Commission itself is going to be monitoring this. It has some extremely capable people who have shown themselves able to deal with the technical things that Google throws at them. But it will be important for them to have help from people like Siobhan and others who understand the guts of how all of this works. And so we'll have to see what mechanisms the Commission comes up with to deal with that, but these tripartite meetings, which Siobhan suggested, might very well be appropriate. The Commission did employ that in the Microsoft context. I participated in some tripartite meetings with Microsoft. They were not especially friendly, but they were useful. So we'll have to see how that develops.
These tripartite meetings could well be friendly. I personally propose bringing brownies.
Okay, Kashida? Please wait for the mic so people can hear and identify yourself.
Kushita Vasant from PAR. I just wanted to check, would you be seeking damages, and can you throw some light on the numbers or jurisdiction, as the Commission press release says that it affects 13 EEA countries especially, and the reasoning behind the damages? Thank you.
So we do have a civil claim.
Foundum.
Foundum has a civil claim, which we filed in the High Court in summer 2012. Yes. And that is our way of recouping the damage that some of the substantial damage that Google's illegal practices did to Foundum. Because there is such an enormous overlap between our civil claim and the Commission's decision, which is unsurprising as we're the lead complainants, you'd expect there to be an enormous overlap. Our civil case was actually stayed in December 2015, because as you know, the decisions that are reached by the European Commission are binding on the various national courts. And now that a decision has been reached, that stay will be lifted.
So maybe I could follow up with just a few legal observations. The Commission's decision is, of course, binding on the national courts. So any complainant who files a case in the national courts has the benefit of the Commission's binding decision with respect to dominance, which is a big thing, and abuse. So if you are a comparison shopping service, you have a very strong position from which to file and succeed in a damages lawsuit. Fair Search is an organization with a number of companies and associations as members. We would not have standing to file any lawsuits for damages ourselves, so Fair Search will not be. And which other companies might be doing so, I simply don't know, and I doubt that Siobhan knows either. But that there might very well be other comparison shopping providers who have been damaged by virtue of this conduct, who might file suits in the future, that could very well be the case. And it's also possible that there could be national court damages actions in adjacent sectors, not necessarily comparison shopping. Again, comparison shopping people have a particular benefit because here we have an actual binding decision that the national courts must regard as binding with respect to illegal conduct in this particular area, comparison shopping. But it might be applied beyond that.
Yeah, I'm with Fair Search. I'm David Lawsky. I'm going to relay two questions that reporters have contacted and sent to me. They're both asking about the legal theory of the Commission, whether it's novel, and if so, can we elaborate on that just a bit?
The first thing I should say is that, as I said before, we have not yet seen the decision. As the Commissioner said, the Commission has to agree with both Google and third parties about confidential information contained in the decision before the Commission's able to disseminate the decision to us and to the public at large. So I'm somewhat limited in what I can say. I have seen the statement of objections, but I also signed personally a statement essentially saying that I would have to move to Siberia if I revealed anything from the statement of objections. So I'm also a bit constrained there. But let me be slightly adventurous and say that, as I think the Commission has essentially indicated, the theory is, in a nutshell, and I have to emphasize again that I've not seen the details, so I'm skating a bit on thin ice here. It finds dominance, and it finds that Google has privileged, preferenced its own comparison shopping service in the way I described before, and by imposing penalties upon folks like Foundum to push down their results. Those are the two basic mechanisms that Google uses. So it engages in conduct which favors its own comparison shopping service and penalizes its competitors. And it has evidence indicating that that conduct has very seriously distorted competition. It has caused foreclosure of competitors. Those numbers, I believe, are going to be pretty straightforward. And so it has found that those are the key factors that need to be found. And I should say it also throws in the basic point about a special responsibility. And that's something that's been in the case law for many, many, many years. If one has a dominant position, one has a special responsibility. The court has indicated, the Commission has indicated over many years that Article 102 is a flexible provision in the EU treaty that needs to be adaptable to whatever circumstances one faces in the market. And that's what the Commission has done here. It's applied Article 102 in a principle-based way that finds liability. I should also say that some have suggested that this is a novel sort of favoring abuse, and although as best I can tell, the exact manner in which the Commission has formulated the theory of harm in this case might indeed be new. It's not in the least bit new for the Commission to find abuses of dominance in circumstances where the basic conduct at issue is favoring one's own adjacent service by somehow leveraging, abusing the dominance one has in the primary market. If you look at tying, for example, that's the nature of a tying case. Tying is taking one's dominant position, and as Microsoft did, it tied Internet Explorer, it tied Windows Media Player to the dominant Windows operating system, and that favored the product, its product, in the adjacent market. It's pretty much what's going on here. Now, the Commission hasn't put this conduct exactly in the tying box, but tying is a form of a favoring abuse. Discrimination, the Unilever case about ice cream boxes, or whatever they're called in Ireland, I think it was, that also involved favoring. They were favoring the inclusion of their own ice cream products in those freezers. And so there's nothing really particularly new about that. So I would contest the proposition that this is particularly novel.
Hi, Thomas. I have another question for you, and sorry if you've already answered this partly in another way. I'm just trying to understand to what extent does this clear the way for those two other cases? Does this decision help? Because the commissioner said that this is a precedent. So how would this apply, or how would this extend to those other cases? And also, could you probably guess or conjecture very broadly, if there were fines on those other two cases, would they be calculated in a compounded manner, or would they be to the same extent this fine was? Thanks.
Well, this decision will, in certain respects, lay a basis for decisions we hope to see in the two remaining open investigations, Android and AdSense, but in a relatively limited way. For Android, the finding of dominance in search is relevant. It by no means enables the Commission to decide the case in one way or the other, but it's a relevant factor. And in AdSense, the finding of dominance in general search would also be quite highly relevant. And again, a finding of dominance is a big thing. I mean, that's a big step forward in any case. So that helps lay the basis for both those cases, and perhaps more so the AdSense decision. But I wouldn't exaggerate the extent to which this decision concretely, specifically, in any sort of detailed, comprehensive ways, lays the basis for findings of liability in either of those two cases. They will, in large part, stand on their own legs. With respect to the fines, I really cannot speculate as to the fines that might be issued in either of those two remaining cases. The fines will have to be calculated according to the fining guidelines with respect to the facts at issue in those cases, and the markets at issue are quite different, and so the relevant figures in terms of turnover and the like will be quite different. So one could have very different numbers. With respect to basically augmenting the fine by virtue of previous unlawful conduct, I don't think that's likely to happen in this case, because the conduct is relatively different, and you know, this case has been just decided today, and I don't expect those cases are going to be decided in the too distant future. So I don't believe there'd be any sort of increase of the fine for that reason.
Thank you. Thomas is going to comment.
Yeah, I can't really resist.
Okay. Go for it.
I actually found it extremely pleasant reading, insofar as it's so easy to rebut. So I'll just go through it. I mean, Kent says in the first paragraph that when you're shopping online, you want to find the products you're looking for quickly and easily, and advertisers want to promote those same products, and that's why Google shows shopping ads that connect users with thousands of advertisers. And then he goes on to reach the conclusion in the next paragraph that Google believes the European Commission's online shopping decision underestimates the value of those kinds of fast and easy connections. That makes no sense whatsoever. The Commission doesn't say anything whatsoever about the value of those so-called fast and easy connections. The Commission, I think, quite explicitly said, Vestager said, these are valuable things to consumers, comparison shopping services. I'm sure Siobhan would heartily agree with that proposition. And we would absolutely welcome Google's participation in this market and the provision of any innovation it is able to provide in this market. What the Commission says is those good things, that value to consumers that is provided via comparison shopping mechanisms, must be provided in a way that provides equal treatment to everybody participating in that market. So Siobhan and Adam are able to compete on a level playing field with Google in this market, and consumers will have the very best, as Google puts it, or Kent puts it, fast and easy connections. Then the next paragraph goes on to say that we think our current shopping results are useful and a much improved version of the text-only ads we showed a decade ago. Now, this harkens back to Google's comments on the Statement of Objections, where Kent Walker also issued a blog and focused in quite a number of paragraphs about the format, the presentation. This decision has nothing to do with presentation or format. As Siobhan indicated, there is no reason whatsoever. It is disingenuous to suggest that the Commission decision requires Google to change its presentation at all. All the Commission decision says that when the Commission is presenting, when it's choosing, when the algorithm is choosing which results to provide, that it provides them on an equal treatment basis. So there's nothing whatsoever with respect to the format, not a word, not an implication. This is simply disingenuous. And finally, and this is also very interesting, there's a fair amount of talk, as there was in the response to the Statement of Objections, about Amazon and eBay. And I would suggest, just very briefly in that regard, that it's rather inconsistent for Google to be claiming here that Amazon and eBay are in this market when it itself insisted in the settlement proposals that it was discussing with Commissioner Almunia that Amazon and eBay had to be excluded from those proposals because they were different. So talk out of one side of your mouth, not both. And finally, it says, when you use Google to search for products, we try to give you what you're looking for. Well, that's fine. Our ability to do that well isn't favoring ourselves. Again, the Commission doesn't say anything about how Google must formulate its own comparison shopping services. Google remains entirely free to decide what to do with its own comparison shopping results. There's nothing in this decision that says a word about that. So again, it is disingenuous, highly disingenuous, to suggest, by virtue of this, that the Commission decision has anything to do with that. That's not the favoring that's at issue. The favoring concerns the results that Google's general search engine chooses to provide to users when they put a query in that demands a comparison shopping result.
Thank you, Thomas. Siobhan, do you want to make a few more?
Yes, I mean, I would agree with everything Thomas said, but I think it's also worth noting that the unpalatable truth at the centre of the Google search case is that if you're looking to buy something, Google has become increasingly particular about exactly how it wants to connect you to the merchants who sell it. So Google over time increasingly wants to connect you to merchants through paid advertisements, which are prioritized by the amount the advertiser is willing to pay, or by its own comparison shopping service, where again the results are prioritized by the amount the advertisers are willing to pay. And both of those obviously generate substantial revenue for Google. I think Bloomberg this morning in an article suggested that about 20% of Google's search revenue is coming now from these comparison shopping ads. And increasingly, Google doesn't want to connect you to merchants through the relevance-based natural search results or via competing comparison shopping services, neither of which generates revenue for Google. So it's interesting that Kent Walker's statement glosses over these important points, and it's not surprising because, of course, convincing users that it's in their best interest to forego relevance-based search results in favour of pay-for-placement advertisements is going to be a really tricky sell. So I think, in summary, I think the Commission has a really, really strong case, and I think it's interesting that Google is saying it's going to consider its position, whether it's going to appeal or not. Personally, I'm very confident that if Google did appeal, they would not prevail.
Okay. yes, if you have, are there any further questions?
Maybe because I get excited about this topic as well, I'd just like to return very briefly to this whole cross-Atlantic question, which does really rather bother me insofar as I have been hearing the same thing for decades. Any defendant in these sorts of cases based in the United States raises this same point. First, just look at the cases. It's simply not true if you actually look at the evidence that they demonstrate any bias on the part of the Commission against American companies. And secondly, I will simply state that I personally, as many of you in this room probably also do as well, but I certainly personally know the relevant individuals responsible for these cases. I don't know Commissioner Vestager personally particularly well, a bit, but not particularly well, but I personally know most of the other officials who have been involved in investigating and deciding these cases, and I can absolutely say without a shadow of the doubt that these are among the more internationally oriented people I know in the world, and they are not in any way anti-American. Indeed, I think if they felt that this case was being driven, this decision were being driven by some form of anti-Americanism rather than the merits of the case, I believe they would resign their positions and move to some other job.
Thank you, Thomas. I think we're going to wind up right now unless there's a last chance for questions. Again, thank you very much for coming, and you know how to reach us if you have, and obviously you can reach us afterwards if you have follow-up questions. I think this will be a continuing dialogue, conversation, yes. Thank you very much.